Good morning to all of you. Now, final year students, we are going to discuss the other two questions in question paper number 2019. So, please refer to question number 17. X, an advocate assaulted his opponent in the courtroom, that means in the court, with a knife, right? So, for this, a case has been registered. He was convicted for offense to commit murder. That means he was convicted under section 307 IPC, right? So, since there is a conviction, so his name was removed from the rolls of the advocates of the State Bar Council. Now, he challenges the decision as it is violative of Article 19(1)(g) of the Constitution of India. Decide. What is the main issue in this case? The main issue is whether if a person's name can be removed from the rolls if he is convicted. 100% yes. 100% yes. Normally, I will tell you that I am telling you that if he is convicted in a case involving moral turpitude, but here also same thing, moral turpitude. He has filed or he has used, actually he has assaulted another lawyer friend, his opponent, with a knife. What more is necessary? He can be removed. But he says Article 19(1)(g), that is freedom to practice any profession or trade. It is his fundamental right. No doubt, a case has been registered when he assaulted the other person. A conviction has been given. That's a different part. But since he has studied law, since he has got the lawyer's degree, since he has appeared for the All India Bar Examination, and since he passed, definitely he can continue his practice. Why this hurdle? This is the main crux of the problem in this case. So, the main issue is whether the name of an advocate who is convicted can be removed from the rolls of the advocates of the State Bar Council or not. Now, when you discuss, please remember the discussion should go on like this. Lawyer's profession is an honorable profession. So, he must maintain dignity. He should not lose his temper. He should maintain the cool in the court. But what happened? So, straight away I am telling you, Hikmat Ali Khan versus Ishwar Prasad Arya. So, in this case, what happened? This man, while discussing the other advocate, he lost balance and he has shot it. Actually, he attempted to shoot him and he has kicked him. Lot of this thing take place. A case of 507 was registered against him. The matter came for trial. During the trial also, he could not manage the witnesses and the witnesses totally gave evidence against him. He was convicted. When he was convicted, definitely the name can be removed. So, best case, please remember. Second, UP Sales Tax Association versus Taxation Bar Association. This case also. So, please remember, you cannot come to the court armed with a pistol. So he came to the court armed with a pistol. When the judge asked him, he said, no, it is my personal defense or self-defense, not agreeable. Right? So it is not violative of Article 19(1)(g) of the Constitution of India. Next question. The Bar Council of India framed a rule stating that a person who has completed 40 years age on the date on which he submits the application for enrollment as an advocate to the State Bar Council shall not be enrolled as an advocate. That means people who have crossed 45 years, they are not fit to practice the legal profession. So Bar Council of India made a rule, framed a rule. So what? Stating that, please remember, a person who has completed 45 years of age. This is number one. And secondly, when he submits his application for enrollment as an advocate, so on the date of application for the enrollment, ఏ రోజైతే అప్లికేషన్ పెట్టుకున్నాడు దేనికి ఎన్రోల్మెంట్కి లా చదవడానికి కాదు పెట్టుకున్నాడు, then if he has completed 35 years of age, then he cannot be enrolled as an advocate, right? So please remember, this rule was challenged as ultra virus of the Advocates Act 1961. Now you have to decide. This is another case. Already Rishabh Duggal versus Bar Council of India. A very famous case is there. Indian Council for Legal Advice and Legal Aid and Advice versus Union of India. 1995 case is also there. Same, they discuss the same thing. So here the main problem is, the issue here is whether the persons who have completed 45 years of age can be enrolled as advocates. So we'll come a little bit down. whether the persons who completed 45 years age can study law or not. Simply this is the main problem. So Supreme Court said yes. But please remember, the Bar Council of India, using its powers, they made the rule that for 5 years, the maximum age is 20 years. For the so-called 3 years course, it's only some 30 years or like that. But people who are aged, like me, even I studied law after my retirement. So how can they be allowed? So this is the case law in which the Supreme Court observed that the restriction of age to enter the legal field is ultra vires. Restriction of age, because even at the age of 80 years, somebody wants to study law. At the age of 21 years, somebody wants to study law. He can be allowed. It is equality. Article 14 says equality before law and equal protection of laws. So therefore, remember, the Supreme Court in the case of Rishabh Duggal versus Bar Council of India 2017 and also Samreen Arif versus the Kolkata University, it has clearly stated that you cannot restrict the age limit of a person to study law. Of course, he has a bit confusingly asked you put this question. So, a person who is completing 45 years of age at the time of enrollment as an advocate, can he file the same or not? Definitely, now I can say yes. But previously, so according to Bar Council of India rules, a person who has completed 45 years of age is not competent to get himself enrolled as an advocate. So there is a contradiction. Now it is very clear in the case of Rishabh Duggal versus Union of India 2017 that any person of any age can study law. If you restrict him, it is against to the spirit of the Constitution. So therefore, you can write that a man of even 45 years and more can study law. And Bar Council has accepted the same also. Only thing is, for the giving the certificate of practice, Bar Council of India may fix certain age restrictions. But for studying law, they need not fix any instructions. This is the decision given by the Honorable Supreme Court. So, in this connection, please remember the case law, Rishabh Duggal versus Bar Council of India 2017, and also Samreen Ali versus the Kolkata University. There another problem, that boy he was allowed to appear for the so-called entrance examination of LLB. He passed, but they did not give him seat because he is more than 20 years of age. So age should be seen at the time of application, not at the time of its ratification. So many problems are there. Anyway, these two cases are of eye openers. Definitely you will get problem in these two cases. Previously these were two cases. These are two cases or more. With this we are stopping the questions in 2019. Right? Okay. We'll be doing some video if I find time. Right. Thank you very much.